So greetings and welcome to the second video in series of the paper discussion that we are having for DJS examination 2023. In this paper discussion, in this video specifically, I'm going to deal with these particular subjects, making a consortium together. I will be dealing with SRA, and I've already told you that in this video I will be taking care of all the civil aspects. Not contract, not consti, not legal GK, not evidence, but the core civil aspects, for example, SRA, then limitation, then CPC, then LLP, although I was thinking of doing LLP in a different video, but I included here only. And then Commercial Courts Act, because if you see SRA, limitation and Commercial Courts Act are all related to CPC. They're the part of procedure, and CCA is also something which brings special amendment to CPC. And then yes, these are the subjects that I'm dealing with. Yes, arbitration, sorry. So arbitration also I'm dealing today in this video only. So this will be a video with the same duration as of the previous video that was based on criminal acts. And then there will be another video, the third video, in which I will be dealing with contract, constitution, and evidence, and legal GK, of course, because that is something which pertains to law. As far as English is concerned, I have my reservations here because I cannot explain you. I'm not an expert in English, but yes, I could have explained you the rules, but the thing is that because I'm not for English, so that is something that I leave up to you, that you can go look in the answer key at what are the answers given, and then you can just cross check with the expert of the language and can see that if the answers are correct and what you marked is right. So today we are going to deal with these subjects today, as in this video. All right, so let's see the questions now. Which of the following contracts cannot be specifically enforced? So say this is question number 11 belonging to SRA. Needless to say that I am dealing with set B. I'm dealing with set B. All right, so you can just look upon your particular set, that what is the question number. The question number given here is belonging to this set. So it is not in series. This is the actual question number that is there in the set B. So it is question number 11. I think you now you are now well versed with these aspects from the previous period, because this is in continuing. It is in continuation that I'm doing the second video. Why I have divided it in parts, I think needless to say, it is for the purpose of you not getting a long video of 3 hours, but at least short video, so that you can just focus upon those particular acts and areas at once. So which of the following contracts cannot be specifically enforced? If you see that this is something related to a contract made by a trustee in excess of his powers or in breach of trust when the act agreed to be done is in the performance wholly or partly of a trust. So it is depending upon the terms of the trust, somewhere related to section 11 of SRA, and then the option is neither 1 or 2, both 1 and 2. If you read section 11 SRA, you will see that the first statement is this, and the second clause 11.2 is this statement, this option. And if you see that clearly, section 11.1 states that shall enforce the act agreed to be done is in the performance wholly or partly of a trust. This can be specifically enforced. It can be specifically enforced. This is what it writes. And a contract made by a trustee in excess of his powers cannot be specifically enforced. Cannot be specifically enforced. ऐसा लिखा हुआ है. This is what is written in section 11. If you want, I will read it for you. I have all the bare acts with me in case that I want to read certain things for you. So the amended portion of it I'm speaking, because in 2018 there was an amendment. I'm reciting the amended portion. Except as otherwise provided in this act, specific performance of a contract shall be enforced when the act agreed to be done is in the performance wholly or partly of trust. This is the statement written, shall be enforced. It is written. Then clause 2, a contract made by a trustee in excess of his powers or in breach of trust cannot be specifically enforced. A contract made by a trustee in excess of his powers or in breach of trust cannot be specifically enforced. This feature can be enforced. This feature cannot be specifically enforced. So the answer would be A, because neither 1 or 2 doesn't make any sense, because it is one of them. Both 1 and 2 are cannot be specifically enforced, also do not suffice. So the answer should be 1. All right. So answer is 11A. Clear? Let's see the second question. A suit for recovery of possession of an immovable property under Section 6. I hope every one of you know what is Section 6. Section 6 talks about a suit for recovery of possession not based on title. It is based upon the cause of action, which is possession and dispossession. It is not based on title, right? Section 5 is something which is based on title, which can be taken only through CPC. So if you have to take the remedy from SRA, you will come to Section 6. So Section 6 is specifically dealing with not based on title. Let's see that what kind of question they have framed. A suit for recovery of possession of an immovable property under Section 6 of SRA is decreed on findings that the defendant was a trespasser. Defendant trespasser है. Plaintiff आया court में. Plaintiff has come to the court saying that the defendant is a trespasser. He trespassed into my land, so kindly evict him. I was in possession. He dispossessed me. I want my possession back. This is the cause of action and the relief claimed. Decreed on the finding that the defendant was a trespasser who had dispossessed the plaintiff by forcibly breaking open the locks of the latter during his absence. He is a trespasser. He forcibly entered into the land and then dispossessed the plaintiff in his absence. He was not there. 5 months before filing of the suits. Why they are calling it, why they are saying 5 months? Because the period of limitation is 6 months. That is given to you from the date of dispossession to file this suit. So he came 5 months before filing of the suits. He was dispossessed. That means it is within limitation. Subsequently, a review petition is filed on the ground that the plaintiff was not the owner but only a tenant. First of all, the title cannot be raised in such suits. I've already told you. Section 6 is not based on title. It is based on only a single fact. There is a dispossession and there was a previous settled possession. So review petition is filed on that ground, and more so, review petition is something which is barred in the section itself. Let's see what options are there. Review cannot succeed, which is correct. Review cannot succeed, but on what ground they are saying? Because it does not lie against decree in such proceedings. It is right. It is correct. This statement is correct. I tell you, I think everyone knows about this. Section 6.3 is talking about this particular provision. Section 6.3. If you see that, no appeal, no review shall lie, this is what is written. So review cannot succeed, which is correct. Let's see, but if there is a better option. The review can be entertained in itself becomes a wrong option because it cannot be entertained. Review can be entertained because ownership is a factor in such proceeding. Ownership is not a factor. So this option does not suffice. The review can succeed. Again, it is wrong because it cannot succeed. Can succeed if it is pleaded that the evidence having a bearing on ownership has been discovered subsequently. You cannot bring the factum of ownership in this section 6. Review can succeed. All the three options are wrong. This is the correct option. Answer is 1. 12 का 1 आंसर है. क्लियर है? बढ़े जी आगे. Specific performance of a contract for payment of money cannot be enforced in favor of a person. Now, specific performance of a contract for payment of money cannot be enforced in favor of a person who fails to ever that he has performed or has always been ready and willing to perform the essential terms of the contract which are to be performed by him. If you see this statement pertains to a particular section in which there are amendments. If you see section 16, the personal bar to relief. So if you see the personal bar to relief for this specific performance of a contract, and in that case, explanation, section 16, explanation after the clause C, explanation part 1 says, where a contract involves the payment of money, it is not essential for the plaintiff to actually tender to the defendant or to deposit in court any money except when so directed by the court. Then it says, the plaintiff must prove the performance or readiness and willingness to perform the contract according to its true construction. So section 16, explanation 1 and 2. Explanation 1 and 2. If you read both of it, then we will be able to assess this, in which it is written that where a contract involves payment of money, it is not essential for plaintiff to actually tender to defendant or deposit in court. Something like that written? Yes. Where the plaintiff has not tendered the money to the defendant or deposited the same in the court while filing the suit, because it can only be done when the court asks you to do so. Such kind of statement is not written. Straightforward question pucha hai. Who fails to ever that he has performed or has always been ready and willing to perform? There is a catch here. Here it is written that initially before 2013 18 amendment, it was ever and prove. Now what remains is where a contract involves the payment of money, the plaintiff must prove performance. Here it is written fails to ever. So that what should come? Prove. So that means this statement is wrong. This statement is correct, but let's see what they say. Specific performance of a contract for payment of money cannot be enforced in favor of a person where he fails to prove. That means this is a wrong statement given. Where the plaintiff has not tendered, that means they both are incorrect. It should be both 1 and 2 are incorrect, both 1 and 2 are correct. Specific performance of a contract for payment of money cannot be enforced in favor of a person where the plaintiff has not tendered. It can be enforced if he is not tendered. It can be enforced if he has not averred. If he did not prove, it can't be enforced. If he did not do that despite the court ordering, he cannot do that. So that means they both are incorrect. Clear? So the answer is both 1 and 2 are incorrect. I hope you got the point. Let's move on to the next. A had awarded contract to B for regular maintenance of electrical fittings, fixtures, cables, etc. of the premise of his industrial unit for a period of 2 years against consideration for the services payable in the agreed sum of money on monthly basis. B abandoned the work after giving satisfactory services for 18 months, citing the reasons of lack of manpower. A files a suit for recovery of money equivalent to monthly consideration for remaining 6 months, pleading that this was the cost of substituted performance through a third party. In such suit, the plaintiff must show having given a notice in writing of not less than 30 days. If you have got the question, you will see that the question pertains to section 20. Section 20 after the amendment is substituted performance. How to procedure for substituted performance. That means what is substituted performance and how to execute it. कैसे इसको carry out किया जाता है. तो facts अगर आप देखें तो इसमें 18 महीने उसने काम कर दिया, 2 साल का कॉन्ट्रैक्ट था, 18 महीने काम कर दिया, 6 महीना बचा है अभी. तो 6 महीना जो और अभी काम करना है वो किसी और से करवाया. तो वो क्या क्या कर सकता है, उसको क्या क्या करना है, वो सब कुछ सेक्शन 20 में लिखा है. दैट मींस सेक्शन 20 इज एलैबोरेटेड ऑफ द फैक्ट दैट व्हाट यू हैव टू डू फॉर सब्स्टिट्यूटेड परफॉर्मेंस in such kind of situation when 6 months are still remaining to be performed, he has not performed, what all you can do. Must show having a given notice, having given a notice in writing of not less than 30 days to be calling upon him to perform the contract within time specified in the notice, and refusal or failure to do so on his part. This is exactly what is written under section 20. If you read section 20, I will take you to section 20 clause 2. See, no substitute performance of a contract shall be undertaken unless the party who suffers such breach has given a notice in writing of not less than 30 days. यही exactly लिखा हुआ है. Then must have got the contract performed through a third party. Must have got the contract performed through a third party. That means third party must have performed it. Is it written somewhere? Where the party suffering breach of contract has got the contract performed through a third party or by his own agency after giving notice under subsection 1, he shall not be entitled to claim relief of specific performance. That means it is important that if he wants to recover the money, that he should have got the contract performed by the third party. May also claim compensation for breach of contract. May also claim. क्या ऐसा भी अलाउड है कि ब्रीच ऑफ कॉन्ट्रैक्ट के लिए आपको कॉम्पेंसेशन मिल जाएगा? Substitute performance if you have already taken, then you cannot ask for specific performance from that party. But can you ask for the compensation? Subclause 4 says so. So 2, 3 and 4 of 20. This will give you the avenue of this question. Subclause 4 says nothing in this section shall prevent the party who has suffered breach of contract from claiming compensation from the party in breach. May also claim compensation for breach of contract. So this is allowed. 4 says. 3 says in for the second. 2 is for the first. That means all the things stands good. And what they are asking, in such suit the plaintiff must show having given this. Yes. Must have got the contract. Yes. May claim. Yes. All the things are correct. So 4 is your answer. All 4 things are there. So 4 is your answer. Next, A has been awarded a contract by an electricity distribution company to lay underground cables and junction boxes at appropriate places to replace the existing apparatus in a residential locality. B, a local resident protests against the work involving enlarging of the capacity of the junction box located near his property, saying this would entail laying of connecting cables for more houses than before, requiring digging of entire footpath facing his house and frequent visits by technicians for occasional repairs. Disturbing his privacy become a safety hazard and a nuisance. As works goes on, his complaints going unheeded. He files a suit against A and the electricity distribution company for injunction against continuance of the work. That means he is going in for a suit for injunction. A suit for injunction. That means you have to deal with a suit for injunction. You have to see that if suit for injunction can be filed against what? Electricity distribution company to lay underground cables. So it is somewhere an infra project. Infra project ही हो गया ना? Let's see. A suit for injunction against an infra project or a developmental project. Then the question is having the options. The injunction cannot be granted because the plaintiff ought to have also prayed for compensation in the alternative. Does not make sense. The injunction cannot be granted because the plaintiff is also to be beneficiary of the work undertaken. Looks like good defense. Injunction cannot be granted because the suit's defective on account of misjoinder of the contractor. Such kind of thing is not actually not the issue when you are dealing with the subject matter, that is injunction. Injunction की जब आप बात करो और इस particular question में यहाँ पर CPC का misjoinder या non joinder की बात क्वेश्चन में आ ही नहीं रही है, तो ये मुझे ऑप्शन सही नहीं लग रहा है. द इंजंक्शन कैन नॉट बी ग्रांटेड बिकॉज इट वुड कॉज डिले इन कंप्लीशन ऑफ इंफ्रा नॉट प्रोडक्ट बट प्रोजेक्ट. इंजंक्शन कैन नॉट बी ग्रांटेड बिकॉज इट वुड कॉज डिले इन कंप्लीशन ऑफ इंफ्रा प्रोजेक्ट. ये कहीं ना कहीं एक पलैटेबल हो रहा है. दैट मीन्स देयर आर टू थिंग्स दैट आई एम फाइंडिंग इट गुड. द इंजंक्शन कैन नॉट बी ग्रांटेड बिकॉज द प्लेंटिफ इज ऑल्सो बेनिफिशियरी ऑफ द वर्क. But being beneficiary does not mean that you will keep on taking the nuisance. You will keep on taking the negatives of the construction of all the developments, because sometimes you may face some challenges that you need to defer. So this also do not look so plausible. Out of the 4, I am finding 4th one to be the most appropriate. But let us see, do we have any provision in that regards? If we see that there are amendments, and in those amendments we have also got a particular section which talks about that what you cannot grant when the injunction may be refused. If you see section 41 and the amendment brought under HA, section 41 HA, section 41 clause HA, if you see that what it says, injunction when refused. An injunction cannot be granted if it would impede or delay the progress or completion of any infra project or interfere with the continued provision of relevant facility related thereto or services being the subject matter of such project. It's an infra project because you are laying down the cables. It's the part of infrastructure. And if would impede or delay, impede means that it will restrict, impede, it will be an impediment, it will be a hurdle, or it will delay it, the time that you have got to make this development happen or to execute the plan, the project. If it is going to delay that, more number of days are going to be added, then in that case you will not give injunction. So fourth one is the best option out of it. So 109 का 4 is the answer. Clear? आगे बढ़े, देखें क्या है. Mr. A filed a suit for partition against his brother Mr. B, claiming 1/2 share in the suit property at measuring 200 square yards inherited from their deceased father through intestate succession. Mr. B disputed the claim and stepped an oral family agreement claiming that the entire suit property fell to his share exclusively. So now these kind of questions you have to actually, all those who have given DJS or all those who are desiring that they should give DJS, these kind of questions must be made a rough, you should make a rough note on that for the with the first extra 15 minutes that you get before starting the examination. Its examination is of 2.5 hours, and before 2.5 hours you get 15 extra minutes. I think this I have already told you when I was doing the PYQ analysis in a earlier video of DJS. When the notification came, then also I told you that 15 extra minutes are supposed to be making rough notes on such kind of questions, because you need to analyze what they are talking about, what fact will then be associated with the options. So let's see what they are saying. They are saying that A filed a suit for partition against his brother B, claiming 1/2 of share of 200 square yards. 200 square yards का half चाहिए उसको, inherited from their deceased father. A is saying that from our father we received this property 200 yards and it belongs to us both, half share, so 100 mine and 100 B's. All right. Then Mr. B disputed the claim and set up an oral family agreement claiming that entire suit property fell to his share exclusively. B is saying that entire 200 yards are mine. All right. The trial court framed issues and the matter was set down. Trial for Mr. A filed his evidence affidavit and was cross-examined. A का cross-examination हुआ partially. At this stage, Mr. A filed an application under Order 7 Rules under 6 Rule 17. Order 6 Rule 17 is amendment of pleadings. This is a question pertaining to CPC. Question number 15 है. ये CPC पे आ गए हैं हम लोग. तो CPC का दिख रहा है अब तो. देखिए क्या, जब Order 6 Rule 17 बोल दिया तो CPC है. For amending the plaint to state that 50 square yards were sold by his deceased father to him by executing an unregistered ATS, GPA, will and affidavit, all dated 1/1/2005. He therefore sought amendment to plead this fact and contended that the partition in the suit is limited to 150 square yards. Now B is bringing a new amendment. B is saying that the suit property is not 200 square yards. Out of this, 50 square yards were sold to him. How? It was sold to him by the father by an unregistered ATS, GPA, will and affidavit. He says that I was willed 50 square yards. How it was willed? By an unregistered GPA. All right. And ATS is, there is agreement to sell, but we are not getting into all those things. Agreement to sell, GPA is general power of attorney, and will every one of you knows. So this is something which is giving confusion. Why? Because what will come into your mind is that how it is actually transferred to you. And the main question comes here that if he was sold it by the father, so at the time he was coming into this family agreement, at the time of the suit, was he not aware of this thing? He was aware. How? Because he says that why he is trying to bring the amendment. He's trying to bring the amendment on the ground that he therefore sought an amendment to plead this fact and contend that the partition in the suit is limited to 150 square yards. देखिए 50 मुझे बिक चुका है. He stated that what is the defense that he is giving? That means what is the averment by which he wants the amendment? What is the problem that he shows? He said the said facts were inadvertently left out by his lawyer. Unknowingly, inadvertently means without knowing. Unknowingly, his lawyer, his advocate did not mention this fact. When he says so when the evidence of the plaintiff is partially done. Evidence of the plaintiff is partially done. If you read Order 6 Rule 17, first of all it says that you have to bring this application before the issuance of before you settle the issues in the suit. Before you settles the issues in the suit, you have to bring this amendment. And even after that, if you are bringing the amendment, then you have to show that you are bona fide. That means you did not do anything wrong, or there is no fault on your part. If I read the exact statement for you, Order 6, Rule 17. Just a moment. Just give me a moment. Order 6, Rule 17 says that provided that no application for amendment shall be allowed after the trial has commenced. After the trial has commenced. Trial commences on the date of settlement of issues. So once these issues are settled and then the trial begins, you shall not bring this application before the court. Do you know that trial has begun? Yes. How do I know? Because cross-examination is happening. Mr. A filed his evidence. Evidence is filed only at the stage of trial. He has already been cross-examined partially. That means trial was going on. So this amendment, prima facie, is not allowed. Then it says what? Unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before commencement of trial. The party, if brings the amending application after the settlement of issues in the trial, then he has to show one thing, that I was keeping due diligence. That means I was duly diligent. Diligent means I was attentive. There is no fault on my part. Can you see the fault? And what kind of defense he's taking? He's saying that what are the ground? Inadvertently left out by his lawyer. You verified the plaint. You are the one to sign the affidavit. It is read by you. If you see the verification, verification is done by the deponent. Deponent is who? The one who brings the list or the one who has the written statement. Lawyer is who? Lawyer is speaking whatever you want him to speak. He is your representative. Such kind of statement does not survive in the court. So there is some contradiction here. So let's see what else. Whether the said application for amendment filed by Mr. A can be allowed. In my view, reading the fact itself, it should not be allowed. But let's see that what are the options given. Yes, because no party should suffer. Yes, in itself is saying that I don't think that it should be allowed. Yes, because no party should suffer due to lapse of counsel and the matter was initially the initial stage of evidence. I have already made you read the proviso. So you know that if this option should go or not. But option looks good. If you see liberally, then this option looks good. Yes, because this is a material fact, as the father of the parties was left with no right, title or interest in the area at measuring 50 square yards with the execution of the sale agreement documents. With the execution of sale agreement, ATS, agreement to sell. With the sale agreement, no title is transferred. I tell you one thing, no title is transferred. Clear? So this also is not a plausible option. No, because Mr. A is deemed to have abandoned his claim based on these unregistered documents. Because of unregistered documents, it is not said that you have abandoned your claim. Mr. A did not abandon the claim. How can Mr. A abandon the claim? Because A has asked for 200 square yards. This option does not suffice. This option is not even in consonance with the issue. No, because an application under Order 6, Rule 17 CPC cannot be moved after commencement of trial. This is what I made you read. And these documents were always within the knowledge of the plaintiff because it happened long time back. And he never raised this issue even in the family agreement that 50 square yards have been sold to me. He always knew it. And the plaint is always verified by the one thing that you have to understand, plaint is always verified by the person setting out the facts, not by the representative, not by your counsel. The counsel only writes there what? If you have seen the plaint or written statement anytime, the counsel writes that drafted by this counsel, and that is why they write that this deponent through me I am talking. So इसमें कोई responsibility नहीं है उसकी. Inadvertent, how? He will write everything. You have read everything. It is said that I have read. Verification is all about reading. So this will not suffice. Any of these options and will not suffice. This option is the best. So the answer is 4. So for 15, answer is 4. आप check कर लीजिएगा, cross check भी कर लीजिएगा wherever it is provided. A civil suit was filed under order 37. 37 is summary procedure of the Code of Civil Procedure. Defendant filed an application under order 37 Rule 35 CPC seeking leave to defend, because in summary procedure you have to ask for leave to defend, because the defendant does not get the right to defend himself. You have to ask for the leave to defend himself, and then there are certain grounds on which the leave is granted. There is a case on this in which the court elaborated that when can you be granted the leave and when you cannot be granted the leave. The said application of the defendant was dismissed by the trial court, and the suit was decreed under which provision is recourse available for the defendant against the said impugned order. C. The said application of the defendant was dismissed by the trial court, and the suit was decreed under which provision is recourse available. Now, if the suit was decreed, that dick likha hai, it should be decreed. And the suit was decreed under which provision is recourse available. See, 115 is revision. Revision तो नहीं लेके जाओगे क्योंकि ये कोई jurisdictional fact पे नहीं हुआ है. It is based upon law. And then section 96 talks about appeal. Appeal जा भी सकते हो. Let's see. 100 makes no sense here. And then 43 talks about the appeal against order, in which it should be specifically written that against this order you can go in appeal to the High Court or to whatever court it is. If we read order 43, if all of you have bare acts, so you can always take them out. मैंने आपको सब्जेक्ट्स पहले ही बता दिए हैं, तो आप bare acts रख सकते हैं अपने साथ साथ चेक भी कर सकते हैं, which is going to be like a good connection to the video, I hope. So let's read what is 43. In 43, Rule 1, it is written appeals from orders. If we see that if any of these circumstances would speak out that against this order of dismissal, can you go to the court in appeal, then this is the good option. Otherwise, 96 is a better option. Let's see which one. So if we see the A1, the order under Rule 10, order 7 does not suffice. Order 9, Rule 9 does not suffice. Order 9, Rule 13 does not suffice. Order 11, Rule 21, Order 21, 34, 21, Rule 72, 92, no. 21 again, 22, no. 25, no. Then 33, no. Orders in an interpleader, no. Then 38, 37 से surpass कर गया 38. Rule 236, no. Then 39, injunction, temporary injunction, no. Order 40, 41, no, not at all. Order 47, no, nothing. So that means this option does not suffice. If you see the texture of section 100, I'm giving you all the evidences that why we are coming to this particular option. If you see section 100, then the nature of section 100 is or the texture of section 100 is just a moment. Is second appeal. Now, section 100 talks about second appeal. 115 talks about revision. Revision is only taken against the ground of jurisdiction generally, where no appeal lies or where there is no option of review. Then you go in revision for only certain facts that are given under 115. Revision in such cases will not lie because it is decreeing of the suit. And because it is the decreeing of the suit, you can always go in appeal. Every decree is appealable unless barred. So 96 is the perfect option. 16(2) should be your answer. I hope you are apprising. Section 2(2) of CPC provides for the definition decree. Which of the following will be included in definition of decree? Order passed rejecting a plaint under Order 7 Rule 11 CPC specifically provided. Order passed allowing an application under Order 12 Rule 6 is also considered to be it is a judgment actually. This order is considered to be a judgment and a decree is passed at the behest. Order of dismissal of suit in default. अगर default पे suit dismiss होता है, default means non-appearance of the party. If there is any decree, any judgment which comes out with the non-appearance of parties, it is not a final adjudication of the matter because it may be set aside. and that is why it is not confining under the definition of the term decree. Dismissal of order 1 rule 10 CPC application. It is an application made, and against an application only an order comes, and against an order, if it is provided that only an appeal can be filed. Otherwise, this order is not every order is not considered to be as a part of a decree. For a decree, it is important that you must have a final adjudication of the matter. That means decree will come with the final adjudication of the main issue in the suit. This is not a main issue. This is something which is related to the impediments. So this is only a small issue in the entire suit. So this will not suffice. This order will not suffice a final judgment under the aspect of the definition to be a decree. ये भी नहीं लग रहा. So both 1 and 2 ये दोनों तो लग ही रहे. 3 should be your answer. ठीक है जी, बाकी देख लीजिएगा, मतलब प्लीज कीप ऑन क्रॉस चेकिंग. आई एम गिविंग यू द एवेन्यू बाय व्हाट मेथड दैट यू हैव टू go about it. Getting the point? Just a moment. Give me a moment. Because if you see rule 6, I'm just reading it for you. It is where admissions of fact have been made either in the pleading or otherwise, whether orally or in writing, the court may at any stage of the suit, either on the application of any party or its own motion, and without waiting for determination of any other question between the parties, make such order or give such judgment as it may think fit, having regard to such admissions. Whenever a judgment is pronounced, if you see rule 6, that is why I just want to give you the addresses. Order 12, rule 6, if you read sub-rule 2, it says, whenever a judgment is pronounced under sub-rule 1, a decree shall be drawn up in accordance with the judgment, and the decree shall be the date on which the judgment was pronounced. So this is included in the decree. Dismissal of the suit in default is not a decree because it is not a final adjudication and it is not on merits. Dismissal of order 1 rule 2 is only an application, and against an application, this order which comes do not suffice to decree. So third is the appropriate answer. I've given you the address. Sarita mischievously takes possession of Namrata's land. Okay, so it was not Sarita's land, but mischievously he took the land from Namrata. Sarita gives it on rent, very good, to Sanjay for a fixed period of time. After the expiry of the lease, Sanjay refuses to hand over vacant possession of the property to Sarita. All right. Thereafter, Sarita files a suit for eviction, which is resisted by Sanjay only on the ground that Sarita is not the owner of the property. Which of the following consequences are to follow? This is something which is very interesting because if we read order 35, there is when we will where we can get some option regarding understanding of this particular fact. This particular fact is that there is one suit property X which belongs to A. It is taken by B from A mischievously. That means by some fraud or whatsoever manner. But now B is in possession of the property X. B gives it on rent to C. Now C is not vacating the premises. B has brought a suit against C. B versus C एक suit आ गया. B has brought a suit against C. C is saying that you are not the owner, so you can't bring the suit against me. Now, can this averment of C suffice? Can he say that you are not the owner? It is A who is the owner. So if you are not the owner, I am refusing your title. Logically, if you see, why would a person who is taking the tenanted premises from someone will afterwards say that you are not the owner? You are not the owner, but you took it from them. Somewhere equity demands. Although I'm not bringing the principles of equity here, I'm just quoting equity, by the way. Somewhere there is a rule which might stop him from claiming in the negative when you already apprised someone's possession over the land. Because when you took the tenanted premises, did you inquire about the ownership? No. What you did, you just took your benefit and you assumed or you presumed that B would have been the good title over the property. That is why you took it on rent. Otherwise, you would have said no. Because if I have any doubt upon anyone's credibility upon the land, then why would I take it on rent from that person? Because the agreement will come with that person only. And now, because it is upon you, the liability is coming upon you because you are asked to vacate the premises, you are saying, no, you're not the owner. So you cannot blow hot and cold. So what will you do? Logically, if you see, C will not be allowed to do that. I will tell you that from where you can get this feature. But let's see the option. Sarita is entitled to a decree of eviction. Since it is not open to Sanjay to question her title over the property. It is not open to Sanjay to question her title over the property. ये पहला ही मेरे को बिल्कुल ठीक लग रहा है. Sarita is not entitled to a decree of eviction since she is not the owner of this property. Only Namrata can maintain a suit for eviction against Sanjay. Which is also okay. The law should also give you this avenue that Sarita is not entitled to decree because she is not the owner. Only Namrata can bring. But look at the transaction. Sarita has given it on rent. C has accepted the existence of Sarita over the property. That means some connection over the property has been assumed by C of B and X. So this also does not, this is otherwise is good in law. But in this particular case, it does not make sense. Then Sanjay has to be evicted, but Sarita cannot be handed over possession over the property since she is not the owner of the property. Sanjay has to be evicted, correct. But Sarita being not given possession is not the issue. The issue is the eviction of Sanjay. It is not the whose title. Issue is not whose title. Neither it is an interpleader suit that where the title will be decided first. And even if it would have been an interpleader suit, what you should have done? Where there are restrictions, I will make you read that particular rule. Don't worry. This also does not suffice. The court should inquire from Namrata if she wishes for Sanjay to continue in possession of the property or to return to possession. Does not make any sense. The court will never do that. Because if that would be the option, then Sarita would never have brought the suit in the first place. ये भी नहीं लग रहा, ये भी नहीं लग रहा, ये भी नहीं लग रहा है, क्योंकि ये इस ट्रांजैक्शन से कनेक्ट नहीं हो रहा. यही आएगा 25 का 1 will be the answer. So the answer would be 25. For the 25 it should be 1. Now why this is the answer? Because if you see this particular question, you may also relate it to CPC, you may also relate it to Evidence Act. If you see that in Indian Evidence Act, it is specifically written. I would take this particular question to Evidence Act, but because the whole concept is related to CPC, that is why we brought also it in the CPC. Sometimes you will see that there are few questions that are related to CPC and special amendment and commercial courts both. So the confusion always prevails that if it belongs to commercial courts or if it belongs to CPC, although they are they are entwined. So if you see, this is the correct option. But why this is the correct option? Because in Indian Evidence Act, you will see that under section 116, the specific rule has been provided that during the continuance of tenancy, you cannot object to the title of the person from which you have taken the possession. So section 116 is talking about the tenant and the licensee. In both the aspects, this belongs to the concept of tenancy. And because there is a continued tenancy, he is not evicting. Now you are not allowed to go against the or dispute the title of the owner. So even if I go by that particular section, this is the correct answer. Even if I don't go by that section, this is the correct answer. Although there might be some confusion between the two, but this is the most appropriate. And also you get a defense of 160 Indian Evidence Act. Clear? So you may say that this question also belongs to Indian Evidence Act. Mr. D was a defendant in a suit for recovery of money. Summons sent for hearing dates 1/2/2019 to Mr. D through registered post was received back with postal endorsement of refusal. Postal endorsement of refusal. Refusal is not found, not available. This is different. If you say that the person not found, that means you did not get him, you could not tell him. That means the knowledge of the fact is not there. So refusal is that he voluntarily asked not to take it. That means he asked him that you take it back. I will not take this. That means he have the knowledge that something has come up. Refusal implies knowledge. Not found does not imply knowledge. There's a difference between the two. This court proceeded ex parte against Mr. D on 1/2/2019, which is a correct approach, because if it is proved that summons are served, opportunity is given, the person is not coming, you can move with Rule 6(1)(a). Order 9 Rule 6(1)(a) talks about the ex parte proceedings. And the ex parte decree was passed in favor of the plaintiff, which is a natural consequence. If you have proceeded ex parte, you will give a decree too on this, and the execution petition was filed. Very good. Then the execution will be filed. The executing court issued warrants of attachment for his bank accounts. Okay. At this juncture, Mr. D filed an application under Order 9 Rule 13 to set aside ex parte decree. Ex parte decree को set aside करने के लिए Order 9 Rule 13 का application डाल दिया of the CPC, praying that ex parte decree of the trial court be set aside on the ground that, क्यों set aside करें? On the ground that he was not duly served. Now the question comes, was he duly served? That means how service of summons is done. Now service of summons can be done if the process server of the court comes with the endorsement and he put it before the court on affidavit that he was there but he refused to take it. That means he had knowledge. He had knowledge that there is a court summons. If the post is sent and the postal department or the postmaster, the postman, he writes as the endorsement that he was there but he refused to take it, that means he had the knowledge that there is something from the court. He is the one to be negligent. He is the one to be voluntarily refusing. It is willingly he is avoiding the summons. It is considered to be as summons served. That means now they can move ahead properly. So there is no problem in this. Order 9 Rule 13 won't suffice. Let's see what are the options. Yes, because Mr. D is entitled to defend the suit on merits. What they are asking, Mr. Can this application be allowed? Yes, because Mr. D is entitled to defend the suit. Yes, he is entitled and he was given the opportunity, but he willingly refused. So why? No, because Mr. D himself refused the summons and was therefore duly served. ये तो बिल्कुल best है. Yes, because trial court ought to have issued fresh summons at the hearing dated. No fresh summons, because when it is proved that summons are served, why fresh summons are to be given? If he was not found, address was wrong, in all these circumstances, fresh summons are issued. None of the above. The best answer is 2. 30 का 2 answer. CPC से pertaining. Mr. A filed a suit for eviction. See, what are the texture of the questions have you seen? So many paragraphs I am reading. There is no factual question so far. All conceptual. You have to apply your mind and then see what is happening. Summons how served and how they are proved that they are served. The proof of the service of summons is something that they were discussing in the previous question, which is given in the CPC. Don't worry, you can read Order 5 properly. Mr. A filed a suit for eviction and recovery of arrears of rent against Mr. Y in respect of a commercial shop basis legal notice dated this. Mr. Y filed a written statement stating that he is not a tenant in the premises and it is his son Mr. X who is a tenant in occupation of the said commercial shop. Mr. A filed an application for impleadment of Mr. X, which is very plausible. See what is happening. A filed a suit against Y. Y says in the written statement that it is not me but X who is the tenant. So A must file the suit against X. So what A would have done? A would have asked the court to replace Y by X or implead X. This is what the A will ask. Let's see what it says. It is saying the same thing. They see Mr. A filed an application for impleadment of Mr. X as defendant number 2. So he wanted it to be added to the list of defendants. In view of the said averments, because Y said so, Y is the father of X. Y is saying that it is not me but X who is the tenant. Call him. Both Mr. X and Mr. Y oppose the impleadment application on the ground that Mr. X cannot be impleaded in the present suit and a separate suit is to be filed. Why? Why a separate suit is to be filed? There is no logic that you will file a separate suit for this purpose. Why? Because Mr. X has been averred by Y to be the tenant. There is an admission made, although this is not the admission by X, but Y said that I am not the tenant, X is the tenant. So A is asking X to come. And that will be the matter of fact and documentation that we will see that who is the tenant, and whoever is not the tenant will be asked to go from the litigation. Y will then go. Are you getting the point? Is this impediment application maintained or not? Obviously it will be maintained, but let's see what are the options. No, as this is a separate cause of action, there is no separate cause of action. It is just the matter of finding out that who is the tenant. That's it. And that court will do properly when the proper parties will come before. Necessary parties have to be found out, proper parties have to be found out, and a fresh suit should be filed. I don't think that this should be the option. No, as the present suit is based on legal notice, this which was not addressed to Mr. X, the proposed defendant. Does not matter, because even if you want to give the notice, when you will file the impediment, when you will give the impediment order, he will be given all the documentations that you must come to the court, and X has come to the court and then opposed that fresh suit must be filed, because an application was made combined by Y and X both. दोनों मिलके कर रहे हैं ना डिफेंड इसको, इसका मतलब X को नॉलेज तो हो ही गई है. Yes, in view of the defense raised by Mr. Y in his written statement, which gives rise to a doubt, so as to enable the plaintiff for grant of the relief sought in the plaint. Looks like good. Yes, as per section 151 CPC. 151 CPC inherent powers are not to be used in such cases. Why? Because there is already an option given under Order 1. Order 1 Rule 10 gives you this avenue that you can add if it is required. So third is the best option. 31. Then next, Mr. G, a hostel owner, rented out one of the rooms to Mr. H at a yearly rent of rupees 1,20,000. Mr. H defaulted for the years 16, 17, 18. Mr. G, after issuing legal notice for the arrears, filed a suit for recovery in 2019 for the rent due of the years 2017 and 18 only. The said suit was decreed in favor of Mr. G on 1/11/19. Whether Mr. G can file a subsequent suit for recovery of arrears of the year 2016. See what happened, that in 2019, he filed a suit for recovery of money or recovery of rent, whatever you want. Recovery of money bolte hain. In 2019 they filed a recovery of money suit, and the arrears pertains to 2016, 17 and 18. In all the 3 years he have not given even a single penny. So he wanted that all the money should come to him. The money from 3 years was accrued. That means around 3,60,000. From 3 years the money is accrued. 3,60,000 accrued है, और वो स्यू किस पे कर रहा है? स्यू कर रहा है 2,40,000 पे. He is only suing on 2,40,000 of these 2 years. Now someone asking, why you are not doing it for 2016? Was that not accrued? It was. So why you have abandoned the claim? Why you are not taking the claim? And if you are not taking the claim, the law constructively presumes that you do not want it. Where it is presumed? Order to Rule 2. Order to Rule 2 says that if you, and this is question based upon the illustration given there. So you can directly come to Order to Rule 2 if there is one. No as per Order to Rule 2. Yes, see. No as per section 11. 11 has nothing to do with it. Res judicata, what is doing here? Order 20 Rule 12 has nothing to do with it. That is judgment. Order 23 Rule 1. Withdrawal of the case. What is this? Has nothing to do with it. Order to Rule 2 is the best option. Order to Rule 2 is when you abandon your claim, you are not allowed to ask about it. It will be considered that you didn't want it. Order to Rule 2 for the relief is strict and sometimes considered as something akin to res judicata only, but not res judicata in the sense of section 11. It's different for relief. Clear? So one is your answer. Where would a suit for compensation for wrongs to a person be instituted if the wrong is committed within territorial jurisdiction of one court and the defendant resides within the territorial jurisdiction of another court? Wrongs. Suit for compensation for wrongs. If I am not wrong, this is section 19 of CPC. Compensation for wrongs. Section 19. Short title, suits for compensation for wrongs to person or movables. Where a suit is for compensation for wrong, it is to be instituted within the local limits of jurisdiction of one court, and the defendant resides or carries on business of personally work for gain within the local limits of jurisdiction of another court. The suit may be instituted at the option of the plaintiff in either of the said courts. किसी में भी कर सकते हो. Place where the wrong took place पे भी कर सकते हो, where the defendant resides पे भी कर सकते हो, where the plaintiff reside, ये तो option ही नहीं होता कभी. Defendant reside, personally work for gain or does business, यही options होते हैं. तो दोनों ये कर सकते हो, either one or two. 4 is your answer. Depending, this is provision section 19 CPC. इसमें लिखा हुआ है. So 4 is the answer. Upon institution of a suit, summons may be issued to the defendant to appear on such day, not beyond 120 days from the date of the institution of the suit, not beyond 90 days. ये तो डायरेक्ट सवाल है भाई, ऑर्डर 8 रूल 1 में है. Upon summons may be issued, ये तो ऑर्डर 5 में भी है, ऑर्डर 5 रूल 1 में. Summons may be issued to defendant to appear on such day, not beyond 30 days होता है वैसे. 4 is your answer. 30 plus 60, 30 plus 90 होता है. So in total it is 120 days. Order 5 rule 1 पढ़ लीजिए. It says when a suit has been duly instituted, a summons may be issued to the defendant to appear and answer the claim and to file the written statement, if any, within 30 days from the date of service of 30 days. उसके आगे provided further that the defendant fails to file the written statement within the said period of 30 days, he shall be allowed to file the same on such other days as may be specified by the court for reasons to be recorded, but which shall not be later than 90 days from the date of service of summons. So, sorry, not plus 90, it is plus 60. So, 90 days from the date of service of summons. Not beyond 30 days from date of institution of suit. Issued to the defendant to appear on such date. Now, date of institution of suit is wrong. This should not be here. Because upon an institution of a suit, summons may be issued to the defendant to appear and answer the claim and to file the written statement of his defense, if any, within 30 days from the date of service of summons on that defendant. It is service of summons. It is not institution of suit. But I guess everywhere it is written institution of suit. But then 30 days is correct. There is again a flaw here. It should be service of summons. यहाँ पर service of summons होना चाहिए, because from the date of institution of the suit, never ever this will happen, that you are asking the defendant to come to appear on the date when the summons may be issued. Summons may be issued to the defendant to appear on such day. Summons, if are issued for the defendant to appear, you will ask him to appear only when the summons is served. If summons are not served, only today you have given the order summons may be issued, then maybe summons are not issued for the next 20 days. He is getting only 10 days. It does not make any sense. So even if you read order 5 rule 1, even if you read order 8 rule 1, you will see that 30 days is from the date of service of summons. It is not the institution of the suit. There is a flaw here. But otherwise, if the option has to be seen, then it is 4. If this flaw is removed. I have the paper, I could see that even there it is, there is a problem. 30 plus 60 total 90 you get. Okay. Nevertheless, so there is a reservation on this particular question too. The court may, on the application of the decree holder, order execution of the decree by delivery of any property specifically decreed only to the extent of the property of the deceased which has come to his hands and has not been duly disposed of, by attachment and sale, yes, by appointment of a receiver, yes, these all avenues are available for the execution of a decree. This is all of the above. This is but natural. 64 का भी 4 ही option है. Nevertheless, you can just find. These are the order 21 also says. Every decree for the payment of money may be executed by either detention in the civil prison of judgment debtor, by attachment and sale, yes, by appointment of receiver. Okay. Is that the same? 64 is this. Okay, yes. All right. There is the question. Every decree for the payment of money may be executed by either detention in the civil prison of the judgment debtor, by attachment and sale, or by the sale without attachment of any property, by appointment of receiver. This is, I think this 65 is not a correct, it is not written correctly. This 65 is not written correctly. I'm very sorry for the slide. That is why I've kept the question paper with me, so that I could just cross check if I feel any problem. The question number 65 set B says, every decree for the payment of money may be executed by either detention in the civil prison of the judgment debtor, this is correctly written, by the attachment and sale of property of the judgment debtor, this is correctly written, this is not written. Both 1 and 2, none of the above. These two options are wrong, although it will not make any difference, because third option is both 1 and 2. 1 and sorry for this typo error. It happens because we have done this very quickly. All slides have to be prepared quickly so that we can just discuss less time. So the avenue of proofreading was not there. Doesn't matter. I'm there. I'm reading the question paper also, so don't worry. कुछ गलत नहीं आ रहा. None of the above. दोनों ही तरीकों से होता है, तो 3 is your answer. ये तो दोनों ही ठीक है. Detention in the civil prison of the judgment debtor by the attachment and sale, or by sale without attachment. Both are possible. The Order 21 writes all these things, so don't worry about that. Summary suits under Order 37 of CPC apply to the following classes of suits. If you read Order 37, Rule 1, you will get this a whole answer. Suit upon bill of exchange, yes, because it is direct. B, yes. Promissory note suit seeking recovery of liquidated debt, yes. Liquidated, that means fixed sum amount. If the amount is not fixed, if you have to find out what is the amount by some calculation or by some factors, then this won't suffice. Based on written contract, suit seeking based on written contract means liquidated debt has to be based upon some contract. That means there must be documents available to us to prove that this is the amount due to you. Suit seeking damages for breach of contract. For breach of contract, if you want damages, the damages are unliquidated damages. And I have told you unliquidated damages. I've told you that what you require for this summary procedure is, or in a summary suit, is liquidated. Liquidate means fixed. Unliquidated means not fixed. It has to be found out. This should not be this is okay. Both 1 and 4 is your answer. 66 ka 4. If a suit which does not seek any urgent relief is filed against a public officer without issuance of prior notice, the court shall see if it is urgent relief. It is based upon section 89. Section 80. Section 80 being the notice. Usme 1, 2, 3. If you read, you will see that the third clause is important here, and also second clause. In the combined reading of it, you will see that in urgent relief, you need not give the notice of 2 months, because it talks about a 2 months notice to the public officer or whomsoever they are talking about, public officer, or if you are going against government, then 2 months notice have to be given. And this is a mandatory requirement. If you do not comply with the requirement, your plaint will be rejected. The plaint is liable to be rejected. Not returned, not accept, none of the above, reject the plaint. Rejection of the plaint is this is a conceptual part of it. It is not specifically given, but rejection of the plaint is what happens. And rejection of the plaint happens due to the availability of Order 7, Rule 11D, because D says that barred by law. It is barred by law. Section 80 is that law. At which of the following stages can the court add or strike out any party to a suit? It can be done in the entire proceeding. Before issuance of summons, before framing of issues, before commencement of trial. I think it is any stage. It should be 4. At any stage you can do that. At any stage of the proceedings you can. 68 ka 4. It is also, you can read under Order 1. I don't think that give the perfect. A plaint under order 7 rule 11 of CPC shall be rejected on which of the following conditions? Correct, does not disclose cause of action. Suit appears from the statement that the plaint is barred by law. अभी मैंने आपको बताया cause of action वाला तो A ही है, ये D है, दोनों ही है, दोनों अवेलेबल है. Both 3 is your answer. 93. Where it appears to the court that there exist elements of a settlement which may be acceptable to the parties, the court can refer the parties for which of the following. This is given under section 89. There are 4 grounds. One is mediation, then arbitration and conciliation, then one is Lok Adalat, and then one is judicial settlement. So it could be anyone. Arbitration भी है, conciliation भी है, all of the above हो गया. सारे तो दिए भी नहीं. Arbitration, conciliation को ये दो अलग-अलग बना दिया. 4 is your answer. The defendant, instead of filing his written statement to a commercial suit, filed an application under order 7 rule 11 of the CPC. The application was dismissed by the court. However, in the meantime, 150 days has passed since the service of summons of the suit on the defendant. Defendant prayed that it be granted 1 week to file the written statement. If you have read Commercial Courts Act and the special amendments of the CPC, Commercial Courts Act and special amendments of CPC are to be read together. It is to be read together. If you read that, you will see that the order 8 rule 1, there is an amendment, special amendment given, in which it is said that 120 days is maximum that you will get to file the written statement. After that, you will not get any relief whatsoever to expedite the proceedings. This amendment was brought by the legislature, and this is fixed. There is no ifs and buts on that, and it goes beyond 150 days. Even if you could see that court was doing something else, so there was a different proceeding going on in the proceedings, and he could not have brought the written statement, the court opines, or the legislature's intent here is to fix it to 120 so that whatever you have to do, you keep on doing, but you bring the written statement within that particular period. So that is fixed. The court, exercising its power under section 151 of CPC, shall grant defendant time to file the written statement. But if you say, according to the general interpretation of such kind of provisions, this is a correct option, that you can use the power under 151. If it is not given, because shall word should not be used so strictly, it can be seen liberally. This looks like correct, but let's see. As it was the fault of the court that the application of defendant under order this was remained pending for a long period, the court shall grant extension of time to the defendant to file a written statement. This is partially true. This also looks good. Why partially true? Because if you see that if an application for rejection of plaint has been filed, the court took time to give the order, and by that time 150 days has elapsed. Court took time, but you can't impute delay or latches on the part of the court, because court is functioning according to its own acumen. That means the court will see the wisdom of the application. The court will see that how the law should be applied here, if it should be rejected or not. The court can take its own time, because court has to apply its own wisdom. Are you getting the point? So you cannot impute upon the court, although you can say that court took time, but you cannot impute upon the court that court is at fault. So you cannot falsify the time taken by the court. So it is partially true but partially incorrect, but makes sense. The court cannot grant extension of time to the defendant to file the written statement as 120 days have passed from the service of summons on the defendant. This also is correct. The court shall condone the delay in filing the written statement as the defendant has shown sufficient cause for not filing the written statement within time. This also looks like correct. Sometimes if you apprise the logic and if you see the law around certain provisions, this is what the court does. Even in under order 8 rule 1, it is written that maximum what you will get is 90 days from the service of summons, but that is something which is not the fixed period because again in various judgments Supreme Court has said that if extraordinary circumstances existed and you get the explanation from the defendant, you can grant him more time after 190 days. But if you see 90 days are given generally, here you are giving 120 days and the word shall is written. The word shall is written. If I read for you Order 8 Rule 1, Order 8 Rule 1 says, general one, the defendant shall within 30 days from the date of service of summons present a written statement of his defense. And if he fails to do that within the said period, he shall be allowed to file the same on such other day as may be specified by the court for reasons to be recording, but shall not be later than 90 days from the date of service of summons. Matlab, only 60 more days will be given, 90 days total. And the word shall is used even here. But again, come certain cases which says that you can be liberal. If even after 90 days he wants to file, you just see the circumstances. If there are exceptional circumstances, you can allow. But if you see special amendment, in its application to any suit in respect of commercial dispute of a specific value, substitute the following. Provided that where the defendant fails to file the written statement within the said period of 30 days, he shall be allowed to file the written statement on such other day as may be specified by the court for reasons to be recorded in writing and on payment of such cause that the court deems fit, but which shall not be later than 120 days from the date of service of summons. 120 days from the date of service of summons. You have given 30 extra days in commercial dispute. This belongs to commercial dispute segment. 30 extra days. And on expiry of 120 days from the date of service of summons, the defendant shall forfeit the right to file the written statement. And the court shall not allow the written statement to be taken on record. So, 3 times shall has been written, 30 days extra already has been given from the general provision, because there are only 90. And then after 90, if you have to go, it is liberal construction, but not that liberal. Here you have given 30 extra days and then written twice, forfeit his right, shall not allow. That means if we go by the words, this option, the best. Although all look good if we see the law, but if we see this particular provision, this particular question, 3 is the best. The court cannot grant extension to file the written statement as 120 days have passed from the service of summons to the defendant. So 120 days are last. It is to expedite the course of commercial. So what is your answer? 3. Most appropriate answer is this. Because we look at the language, we look that it is strict. You forfeit the right, they are saying, shall not allow. Again they are saying, shall not allow. The court shall not allow. That means it is strict enough for 120. You have already allowed 30 days extra. In which of the following situations can stay of subsequent suit be granted under section 10? 10 is about sub judice. Let's see, you remember the ingredients and then you see what is written. Where the previous suit between the same parties pending before a court which prima facie does not have jurisdiction. No, this cannot be. Stay cannot be allowed here because does not have jurisdiction. They have to be both of jurisdiction. First suit has reached the stage of final arguments. Okay. Where the matters in issue in both the suits are substantially similar and it's pending between same parties, makes more sense. Where previous suit between the parties on same issue has been decided on merits, this is res judicata, not sub judice. So this will not suffice. This is the best option. 3 we have. 3 is your answer. 149. Which of the following is not a legal entity and therefore cannot sue as a plaintiff in its own name? Now, this belongs to, I think, is Commercial Courts Act. That which of the following is not a legal entity and therefore cannot sue as a plaintiff in its own name? Okay. Which is not a legal entity. If you see, Commercial Courts Act का तो कोई काम ही नहीं है. You can see that registered partnership firm can sue, although it is not a legal entity. It is a legal, not legal entity in that sense. It is not having a separate legal existence from the partners, but collectively the partners make this entity. HUF is also collectively can sue and can be sued. Statutory authorities anyhow can sue and can be sued. So what remains is sole proprietorship. It is not a legal entity and therefore cannot sue as a plaintiff in its own name. So in sole proprietorship, the sole proprietorship name cannot be used. You have to go by the name of the person who is the sole proprietor. So that is what it says. Which of the following is not a legal entity and therefore cannot sue as a plaintiff in its own name. That means you cannot go by the name of sole proprietorship. For example, if I have a sole proprietorship by the name of, for example, Desi Ghee. I'm selling Desi Ghee, but I'm a sole proprietor. I have a name Desi Ghee sole proprietorship, or the name is स्वादिष्ट देसी घी मेरा नाम सोल प्रोप्राइटरशिप का है, तो मैं स्वादिष्ट देसी घी पे नहीं जा सकता नाम पे, मैं अपने ही नाम पे जा सकता हूँ, whatever my name. So you understand, sole proprietorship is the answer. One. Okay, we just read quickly. In which of the following situations after the framing of issues does the defendant have a right to begin evidence prior to the plaintiff in a civil suit in view of the provision of Order 18 Rule 1? If you have read Order 18 Rule 1, you know that whenever there are admissions, 18 Rule 1 पढ़ा हो तो जब भी admission हो जाए कि हाँ हाँ ये सब सही बात है, तो बस जो उसको डिफेंस लेना है उतना ही डिफेंस अलाउड है. Order 18 Rule 1 में लिखा भी हुआ है. If you want me to read, the plaintiff has the right to begin unless the defendant admits the fact alleged by the plaintiff and contends that either in point of law or on some additional facts alleged by the defendant, the plaintiff is not entitled to any part of the relief which he seeks. In which case the defendant has the right to begin. ऐसा अगर लिखा है तो वही है. Where the fact on the plaintiff admitted by the defendant but plaintiff's entitlement to relief is contested in law on the basis of additional facts asserted. यही सही लग रहा है, बस यही तो लिखा हुआ है. The defendant seeks permission to lead evidence first due to the old age. कभी भी नहीं. Either party can elect to begin first. No, not at all. Both 1 and 2 नहीं. It is 1. पहला ही स्टेटमेंट बिल्कुल उससे मैच कर गया जो लिखा हुआ है, कोई आगे क्या जाना है. Whether the service of summons through email without a copy of the plaint is valid service for reckoning the period of limitation for filing of the written statement, मेरे ख्याल से no. Yes, the defendant must approach the court registry for obtaining the copy of plaint. ऐसा नहीं होता. You have to supply the copy of plaint. No summons must be accompanied with a copy of plaint. सही कह रहे हैं. Yes, the defendant must contact the plaintiff for the paper book. Not at all. It is not the duty of the defendant to do anything with that regard. It is the duty of the plaintiff to supply with the copy of plaint with the summons, which is one of the requisite. Otherwise, summons is not considered duly served. You read order 5, you will get that. No service by email is not valid service, even if accompanied with a paper book. ऐसा भी नहीं है. Service by email is a valid service now. So it is ordained by the High Courts. So यही no, ये वाला थी 2. 152 का 2 answer. In which of the following situations is review maintainable under section 114 of CPC? Okay. Discovery of new evidence on question of fact which despite due diligence was not within the knowledge of party at the time when the decree was passed. Perfect है ये तो. Challenge to a finding of fact on the basis of unimpeachable evidence which inadvertently not be filed at the time of original hearing. Challenge to a finding of fact on the basis of unimpeachable evidence inadvertently not be filed at the time of original. If it is not filed at the time of original hearing due to not knowledge, then okay. Otherwise, क्योंकि ये ठीक है पर ठीक नहीं भी है. But the decision on a question of law on which the judgment of the court is based has been reversed by a superior court in another case. If it has been reversed by a superior court, then you have to go in appeal. You cannot go otherwise. Although sometimes they go that it has been reversed, but Supreme Court judgment is always retrospective, prospective, not retrospective. So it will not have any bearing unless it has been asked, so not apprised. Reappraisal of the evidence on record to find out the error in the finding of fact. No, you cannot do. I think the best option is this one. One is reappraisal of evidence is not allowed in review, and that to find the error in the finding of fact. You want to find the error in the, you do not have to find the error. The error must be apparent on the record. Apparent means it can be seen just by reading that you have done the error. If you have to find the error, review is not the solution. Then you go to appeal. Do civil courts have power to grant status quo ante? The defendant has dispossessed the plaintiff from the suit property in violation of the subsisting interim injunction. during the pendency of the suit? Yes, yes, yes. Why not? Because if you do not comply with the court's order and still you do something which is against the order, then you can always grant status quo ante. Yes, yes. 94th does not make any reference. 39 rule 2A, yes, it is temporary injunction, so it is directly relating to it. Section 151 is always read with. No, only the High Court an issue, ऐसा कुछ नहीं है. High Court is not. No, the plaintiff will have to file a fresh suit seeking possession. No, no, no. You can do that in the case itself. Let's see order 39 rule 2A. What it says. Rule 2A, consequence of disobedience of breach of injunction. In the case of disobedience of any injunction granted or other order made under Rule 1 or Rule 2 or breach of any terms on which the injunction was granted or the order made, the court granting the injunction or making the order or any court to which the suit or proceeding is transferred. See, the court granting the injunction may order the property of person guilty of such disobedience or breach to be attached, and also may order such person to be detained in civil prison not exceeding 3 months unless in the meantime. Although it does not relate to it specifically, but this is not disallowed. I would say that this question is not properly framed. It is more of practical understanding, less of theoretical content. So I would not rate this question to be a good question, but out of these four, this is a better option, because 94 does not make sense. Section 94 is supplemental proceedings, and in 94 you do not go. This is more practical, what I am saying right now, less of. If we see 94, to prevent the end of justice from defeated by court, it is prescribed issue of warrant direct to furnish security, temporary injunction in case disobedience commit. 94C says that in order to prevent the ends of justice from being defeated, the court may, if it is so prescribed, grant a temporary injunction, and in case of disobedience, commit the person guilty thereof to the civil prison and order that his property be attached and sold. So it is saying the same thing what is said by 2A, but because it does not say about that there is already an order in violation of the subsisting, they are writing in violation of subsisting interim injunction. So when there is already an interim injunction, and if you violate those, they have power to grant status quo ante. Or anyhow, when you are in disobedience, they can do that, obviously, and they can also attach and take that person to the prison. The most appropriate is this only. It is not a good. It is not an answer, a question framed properly, but the answer is. The better answer is 1. Okay. A civil suit form infringement of trademark with application under Order 39 of CPC and Order 26 Rule 9 CPC was filed by the plaintiff. During the subsistence of a caveat filed by the defendant under Section 148A of CPC, the court, however, without issuing notice to the defendant, granted ex parte ad interim orders in favor of the plaintiff, whether the court was correct in doing so. Okay. Let's see this question once. Okay. So it is all about caveat, belongs to CPC only, because 148A of CPC is written here, and Order 39 CPC, Order 26, Rule 9 CPC, about commissions and the temporary injunction. Okay. The court, however, without issuing notice to the defendant, granted ex parte ad interim orders in favor of the plaintiff, which can be done by the court. Ad interim injunction hai, final injunction nahi hai. Because application is given for temporary injunction, and during the subsistence of a caveat by defendant under Section 148A, because 148A caveat is filed mainly for the purpose of asking the court that whenever you are deciding anything, call us. This is caveat. Kindly we be heard before you do anything. So, but an ex parte ad interim order is given in the favor of plaintiff, which happens. Whether the court was correct in doing so, let's see. Yes, the court was correct since the reliefs sought are urgent and any prior intimation to defendant would have led to mischief. Not that correct. No, since purpose of lodging a caveat is to grant an opportunity to defendant to show cause why any order adverse to the defendant should not be passed, which is the object of filing caveat. If you're not complying with it, then you are making an illegal order, which is yes, but let's see more options. No, as the court has no power to grant an interim injunction without hearing the defendant. ऐसा भी नहीं है. You can grant interim order without hearing. This is wrong. So ये option सही नहीं. Yes, as the court has discretion to grant interim order ex parte without hearing the defendant, where delay would defeat the interest of justice. This looks like okay, but the thing is that you have already filed caveat. That means you know who the defendant is, who is going to be in problem. So you can always call before even doing anything. Because what time you take is to call the defendant and see the objections. If they have filed the caveat, then you can always call them on that day. That on this day they are coming, kindly come and see. So I think the better option is this too. Purpose of lodging caveat is to grant opportunity only. This is the object why you file the caveat. It is to ask the court that kindly hear us. Otherwise, it makes no sense if you are filing caveat and they are not listening to you. Then what is the purpose of caveat? 2 is your answer. What is the limitation for filing an application for leave to defend? ये तो सबको ही पता है 10 दिन. ये लिमिटेशन एक्ट में भी लिखा है और ऑर्डर 37 में भी है. ऑर्डर 37 CPC also have this, limitation act also. A executed an agreement with B at Delhi promising delivery of goods at Chandigarh. The goods were duly delivered by A at Chandigarh and accepted by B. Their invoice recorded that courts at Gurugram will have exclusive jurisdiction as the registered office of A was located at Gurugram. Upon non-payment of money, A sued B at civil court Gurugram. B objected to the territorial jurisdiction of the court. करना भी चाहिए. देखिए हुआ क्या है? Agreement executed at Delhi. So you may say cause of action at Delhi because agreement executed at Delhi. Promising delivery goods of at Chandigarh. This is Chandigarh. So delivery of goods मतलब the execution happened in Chandigarh. TDG लिख देता हूँ. TDG is that train code है ना चंडीगढ़ का. दिल्ली का DLI भी है और NDLS भी है और बतेरे दूसरे सराय रोहिला सब है. तो mainly the Nadire Pudire New Delhi railway station. So DLI and NDLS. Okay. तो दिल्ली में एग्जीक्यूट हुआ है और यहाँ सॉरी दिल्ली में कॉज ऑफ एक्शन राइज हो रहा है because you contracted in Delhi. So Delhi is the place where you actually came into contract, which becomes the jurisdiction. Chandigarh mein you delivered, the cause of action might arose there too. So that the Chandigarh also becomes jurisdiction. And why Gurugram is coming into picture? Their invoice recorded that courts at Gurugram will have exclusive jurisdiction, as the registered office of A was located at Gurugram. If registered office of A was in Gurugram, then you would have come to Gurugram and did that. Why you are executing it at Delhi? Wherever the place is, because in Delhi they would be having a regional office. So wherever you have done it and it's a regional office, then that becomes a place of Gurugram has no role to play here. So you cannot have a territorial jurisdiction at Gurugram. What they are saying, this suit at Gurugram is not maintainable. क्या लिखा है? Is not maintainable as no part of cause of action arose in Gurugram. Yes, यही ठीक. As B is not a resident of Gurugram, doesn't matter. कोई cause of action arise हो ही नहीं रहा. 3 is your answer. 3 is the better answer. You can read section 20 and all those for that. Else use T for the decree of possession of suit. So many questions, only paragraphs. This is what they make the question paper. This is how they make the question paper. Every question you have to read several facts. Your mind is constantly working. Not even a single question I have seen so far in which I am relaxed. Look at the texture of questions that they are putting in DJS. They want you to be consistently into concepts, consistently into reading, understanding, analyzing. So the practice is different. Every question, 5, although maybe it is very easy to answer, but you have seen the past few questions, I am also struggling to get to a perfect option, because these things are not directly written anywhere. That is why they all are conceptual questions, because I have to analyze, I have to filter, I have to see that if I know it or not. If I don't know, I will leave it. And some because of certain exposures, I may say that okay, I may know it, but I have to admit even I would not know everything. You understand this fact? So this is what the practice is. This is where your mind should work. That is why I always say work on the state first. There are many who would tell you, although it does not the part of video, but yes, please listen to it. There are many who would tell you that just cram, just prepare for pre. You are not only to cram, you are also to get into the profession properly. And this is the best way to get into the profession. Keep your mind working, your concepts revolving. Your brain should always keep on stirring the concepts and keep on entangling them with each other, so that you know where is what, how much, with what value. Only then you will be in habit of filtering out. Otherwise, it is a tough task for you to even see that what should be the answer, because it is not written anywhere. These are not factual questions. See, now again a paragraph, else use T for decree of possession of suit property and mean profit. T fails to file its written statement. The possession is handed over during pendency of suit. The prayer for damages is decreed with the consent of the parties to be paid to be at rupees 15 lakh. Damages is decreed with the consent of parties. Oh, okay. You have to pick the main areas, that main statement that will give you the avenue of understanding the facts. See here, all this is of no value. This statement is of value. Prayer for damages decreed with the consent of the parties, but you never know what they are asking. For 15 lakh in 4 installments, T is unable to pay said damages, and therefore T challenges the said decree on the ground that the said amount has been decreed by the civil court without any evidence being led by the plaintiff. If he is saying that it is decreed by without any evidence led by plaintiff, you consented to it. The damages are decreed with the consent. Why did you consent? You would have asked court to give it on merits. And on, see, they are asking about appeal. On consent decree, no appeal lies. No appeal lies under section 96. Without even going further, I could say that it is one. But let's see. No appeal lies under section 96. Yes. Oh, sorry. No, not an appeal. Okay. No appeal is this. I'm sorry. 2. 2 is your answer. An appeal hai. Maine no padh diya usko. An appeal lies? No, not at all. No appeal lies because 96(3) says the consent decree ke khilaf appeal hi nahi hoti. A revision can be maintained before the High Court. Yes, you can do that. An application under section 151 to CPC for setting aside decree, no, this cannot be done. Revision ja sakta hai, but the ground that they have taken, that without any evidence, it is not about jurisdiction. That means the extent of revision, the grounds on which you will take revision is not been pleaded here. So ye to ho hi nahi sakta. Although revision can be taken, but revision has its own extent and scope, and this ground does not come under the scope of revision. Ye bhi nahi. Yehi hai, 2 answer. A suit for specific performance was filed by Mrs. A against Mr. B. The summons in the suit were issued on this, and the same was served at his residence on the adult servant of Mr. B. Yahi gadbad ho gayi. Adult servant. Servant is not someone to be understood as on whom you can serve the summons. ये मैं देखते ही बता सकता हूँ, क्योंकि ये मुझे पता है. CRPC, CPC में दोनों जगह लिखा है. In both the places, in CRPC and CPC, you cannot summon the, you cannot serve the summons on servants. Clear? Was the only person found specified in the summons the trial court whether the service in this case of servant valid? देखो सीधा यही पूछ लिया. Not valid, कहीं भी लिखा होगा not वही है. Yes, because as per order 5 rule 15, CPC service may be done on an adult member of the defendant's family. May be done on an adult member, but this is not adult member. Yes, because as per order 5 rule 14, CPC service may be done on agent of the defendant, not servant. No, because as per order 5 rule 15, CPC service cannot be effected on a servant. Yes, this is the answer. No, because as per order rule 5 rule 14 a servant cannot be treated as an agent, इसका कोई मतलब नहीं. This is the most appropriate and correct 3. 183 का 3. Clear? Which of the following is considered to be body corporate under LLP? Now for this you have to go to limited liability. CPC के मेरे ख्याल से खत्म हो गए होंगे questions. That is why we came to LLP now. And LLP में क्या body corporate है, उसके लिए आप सेक्शन 2 पे जा सकते हैं, सेक्शन 3 पे, सॉरी 3 में जाएंगे. जस्ट मिनट, 2 ही होना चाहिए, हाँ 2 में डी पे जाएंगे तो सेक्शन 2D, उसमें सब लिखा ही हुआ है. कॉर्पोरेशन सोल भी है, बिल्कुल है. कोऑपरेटिव सोसाइटी वोसाइटी सब है, कहाँ है. कंपनी, विच ऑफ द फॉलोइंग कंसिडर्ड टू बी अ बॉडी कॉर्पोरेट, तो कंपनी इनकॉर्पोरेटेड आउटसाइड इंडिया, ये भी है क्या? नो. Okay, it does not include. Okay. Body corporate means a company as defined in clause 20 of section 2 of Companies Act and includes a limited liability partnership registered under this act. LLP incorporated outside India, company incorporated outside India. ये तो गड़बड़ हो गई. Considered to be a body corporate, तो ये तो considered है, ये नहीं है. ये दो तो not include लिखा है, but does not include. तो इसका आंसर तो 2 होना. देखो, if I am not wrong. क्लियर है इसके हिसाब से? तो आप सेक्शन 2 पढ़ लीजिए, सेक्शन 2D, बस इसमें सब लिखा ही. आगे बढ़ते. What are the consequences in a case wherein the number of partners in a limited liability partnership falls below 2 partners and one partner still carries on business for more than 6 months while having the knowledge? ऐसे केस में तो उसी पे लाइबिलिटी डलती है ना जो सामने आ रहा है. That means the person who is who is continuing in the partnership. I think this belongs to section 6 if I'm not wrong. Must at least have 2 partners and at any time who is the only partner is so carries business after those 6 months and has the knowledge of the fact that it is carrying on business with him alone shall be liable personally for the obligation. The person who knows he alone is the remaining partner and still carries on business, personally liable. ठीक है. The person who is the remaining partner still carries on business, continuously jointly liable. No, क्योंकि because it is more than 6 months, तो 6 months के बाद तो ये नहीं बनेगा. The person who is the remaining partner still carries on the business is not liable for any liability. ऐसा तो हो ही नहीं सकता. None of the first is your answer. 1 ये है आपका. Under what circumstances can a LLP be wound up by the tribunal? Winding up is given under LLP, I think around section 64, 60s में ही है. I think section 64 is. हाँ, circumstances in which limited liability partnership may be wound up by tribunal. If decides that LLP be wound up for more than period of for a period of more than 6 months, the number of partners LLP is reduced below. Period of more than 6 months, the number of partners of the limited is reduced below 2. ये तो लिखा ही हुआ है B में, ये तो B ऑप्शन है. ओके. Acted against the interest of sovereignty, ऐसा भी कुछ है क्या? हाँ जी बिल्कुल, D में लिखा हुआ है. This is in D. Tribunal is of the opinion that it is just an equitable, that just an equitable भी है क्या? बिल्कुल है F में. All of the above हो गए, सारे लिखे. Section 64. 4 is your answer. स्टे तो स्ट्रेट फॉरवर्ड था जी. A suit फिर आ गया वही पैराग्राफ. A suit governed by Commercial Courts Act 2015 was filed by Mr. A against Mr. C. Mr. C served with summons. Mr. C was called on to file written statement to the said summons within 30 days. Allowed है. The same was filed by Mr. C on, ये देखो जी 132 days आ गया. With an application seeking, तो सेम ही हो गया. विद एन एप्लीकेशन सीकिंग कॉन्डोनेशन ऑफ डिले ऑफ 1, वो तो मिलेगा ही नहीं ना. कमर्शियल कोर्ट एक्ट का स्पेशल अमेंडमेंट, ऑर्डर 8, रूल 1, स्पेशल अमेंडमेंट, 120 days फिक्स्ड, नॉट इवन अ डे एक्स्ट्रा, forfeit right, court shall not grant. यहाँ तो मिलेगा ही नहीं. Can the said written statement be taken on record by the concerned commercial court? Not at all. कहीं नो है? हाँ जी नो है. No because written statement is mandatory filed within. बिल्कुल सही. Mandatory filed ये तो नहीं. यही आ गया बस. ये 2 के अलावा देखना क्या है तुम्हें. 2 is your answer. 120 fixed है, कुछ नहीं कर सकते. For the purpose of determining jurisdiction of a commercial dispute under the Commercial Courts Act, which of the following factors ought to be considered? अच्छा jurisdiction के लिए हाँ हाँ एक there was a section. This is Commercial Courts Act and jurisdiction of commercial court, section 6. Yes, section 6 says so. Section 6. In the commercial court shall have jurisdiction to try all suits and application relating to commercial dispute of specified value arising out of entire territory of state over which it has been vested territorial jurisdiction. Territorial jurisdiction and specified value दोनों ही है. Only specified नहीं, territorial jurisdiction भी दिया हुआ है. Neither. This first is your answer. ये तो straight forward ही था. This you have to call out. Aggrieved by the judgment in the decree passed in commercial suit, the defendant filed an appeal to the commercial division of the High Court. Which of the following is correct? The period of limitation for filing such appeal shall be governed by Article 116 and 117 of the Limitation Act. Period of limitation for filing such appeal shall be governed by 13(1)(a). I guess 13(1)(a) जिसमें लिखा हुआ है. The period of limitation for filing such appeal shall be governed by 13. दोबारा हो गया क्या? एक मिनट. 13(1)(a) of the Commercial Courts Act 2015 and Section 5 of the Limitation Act shall also not be and Section 5 of the Limitation Act shall also not be applicable in case there is delay in filing. Oh. However, if there is delay in filing the appeal, the same can be condoned under Section 5 of the Limitation Act for sufficient cause. Second paragraph में दोनों में फर्क है. There is no period of limitation prescribed for filing the appeal. ऐसा नहीं है क्योंकि 13(1)(a) as far as I remember 13(1)(a) में Section 5 का तो as such mention नहीं है. But I don't think that it is barred also. If it is not barred, it will be given. 13(1)(a). Any person aggrieved by the judgment or order of the commercial court at the level of district judge, commercial division of appeal to within 60 days from the date of judgment and order, provided that appeal shall lie. There is no bar of Section 5. If there is no specific bar of Section 5 condonation of delay of limitation act, then it applies because even Section 5 says so. So ये तो third is your correct. This बहुत specifically पूछ लिया है इन्होंने. Now here the concept is coming. And Limitation Act Section 5. It applies to all where it is not barred. ये concept अगर आपको पता है तभी आप ये question सही कर सकते थे, नहीं तो नहीं होता है. ये confusion में था नहीं तो. Because it is not written specifically anywhere in the act. Good question. Good question. Disputes arising out of which of the following is not a commercial dispute? ये तो सेक्शन शुरू में लिखा हुआ है शायद. सेक्शन 2C 21C. सेक्शन 21C. Commercial dispute means a dispute arising out of क्या है? Construction infra आ गया है. 6 पार्टनरशिप एग्रीमेंट ये भी लिखा है. 15 जॉइंट वेंचर ये भी लिखा है. अब 3 आ गए तो इसमें नॉट लिखा है जो, तो ये 3 आ गए हैं तो ऑब्वियसली यही है. HUF पार्टीशन ऑफ HUF 4 इज द आंसर. हाँ HUF दिख भी नहीं रहा. You would be seeing that I am looking at the Bare Act. Why I don't remember it? How can I remember everything? I have not prepared for the examination, so to cram it. But yes, I have read it, so I know that where we can find it. 114 ka 4. A raises a claim of rupees 5 crores in arbitration. B raises a counter claim of rupees 2 crores in the said arbitration. A final award of rupees 4 crores is passed in favor of A. Specified value for determining jurisdiction of the court shall be, jurisdiction is uh, mhm. It is section 12. Yes, section 12, that too, section 12.2 states that the aggregate value of the claim and counterclaim. What is the claim? 5. What is the counterclaim? It is 2 crores. The aggregate value is 7 crores. 5 plus 2, 7 crores. है क्या? ये रहा जी आंसर. 2. Aggregate value of claim and counterclaim, if any, as set out in the statement of claim and counterclaim, if any, in an arbitration of a commercial dispute, shall be the basis of determining whether such arbitration is subject to jurisdiction of commercial division, commercial appellate division, commercial. Pecuniary jurisdiction find out करने के लिए 12. In a commercial suit, an application seeking a summary judgment under Order 13A CPC can be filed by the plaintiff along with the plaint before service of summons on the defendant, after summons have been served on the defendant, and prior to framing of the issues in respect of the suit at any time before the final judgment is passed. Order 13A. Let's see quickly. Order 13. Yes. And then order 13A. Very good. If we see, yes, order 13A, rule 2, it is given. An applicant may apply for summary judgment at any time after summons have been served on defendant, provided that no application for summary judgment may be made by such applicant after the court has framed the issues in such respect. After summons, before issues. कहीं है? Yes. 3 is there. In a commercial suit, along with the plaintiff must file documents that support his case, and can answer the defense that the defendants are likely to put up, that are relating to C. If you see this generally in CPC, you will see that they are asking about the documents that are in possession and power of the plaintiff, but there are certain differentiations. That means there are certain other clauses. For example, there is order 11 rule 1B. Order 11 rule 1B, where it is written that that are related to any matter in question in the suit and can be easily located back. Relating to any matter in question in the suit are in his power, possession, control, or custody, exact the reiteration on the date of filing the plaint, irrespective of whether the same is in support or adverse to his case. If you read order 11 rule 1B, you will find the same exact excerpt. In a commercial suit relating to a movable property, the specified value shall be determined by the market value of movable property when it was purchased. The market value of movable property at the time of filing of suit. यही correct है. The amount that may be notified by valuation officer, no. The amount that may be determined by the court after the parties have led their evidence. I'll just tell you quickly. It is section 12 only. खुला ही हुआ है. Section 12B. Section 12B. It is as on the date of filing of the suit, appeal, or application. Filing of this. So I have read. 2 is it? A dispute arising out of a construction and infrastructure contract shall be a commercial dispute. The above statement is true only if the contract relates to the construction of a commercial building. The above statement is true only if the dispute is for recover of money under the contract. The above statement is false. The above statement is true. देखो यहाँ true to पे 2 conditions लगाई गई, only if, और यहाँ सिर्फ true है. And as far as you see, section 21C में भी लिखा ही हुआ है कंस्ट्रक्शन एंड इंफ्रा कॉन्ट्रैक्ट इंक्लूडिंग टेंडर्स, उसके अलावा कुछ नहीं लिखा. ये सही है. ऐसे क्वेश्चंस को अटेम्प्ट करना थोड़ा जटिल हो जाता है, बिकॉज इफ यू हैव read only section 21C and you have not seen any other sections, you will always be confused कि आपको हमेशा लगेगा कि यार हो सकता है इन दोनों में से भी कोई हो, कहीं किसी सेक्शन में लिखा हो, मैंने सारा नहीं पढ़ा। इसीलिए जरूरी हो जाता है दैट यू आर रीडिंग ईच एंड एवरी सेक्शन प्रॉपर्ली, रिमेंबरिंग, कनेक्टिंग इट विद अदर थिंग्स, because in such kind of states such kind of questions may come, and if in such case that you are confused in such kind of questions, leave it, कोई दिक्कत नहीं, इतना तो छोड़ ही सकते, because even I got confused, even I have to take out that what is the answer, I would have left it. So this is true because I could not find this anywhere. So 4 is your answer. See, truthfulness is not bad. X and Y being both juristic entities have certain commercial disputes which have arisen under a contract which does not contain any arbitration clause, because till now whatever questions we have seen from Commercial Courts Act, they were very straightforward. It is only the matter of reading, and you read these sections from which they have asked the question. You generally read these questions, and from Commercial Courts Act they have asked not less than 9 questions, which is a big number. If I am not wrong, yes, 9 questions they have asked from Commercial Courts Act. They are increasing the number of questions day by day. X and Y being both juristic entities have certain commercial disputes which have arisen under a contract which does not contain any arbitration clause. X wishes to resolve these disputes through arbitration, and for this purpose seeks to have an arbitration agreement with Y. Which of the following is a possible option for X for the purpose of bringing about an arbitration agreement? Agreement कर लो, addresses a letter to Y proposing that the dispute be resolved through arbitration and calling up, सही है. Enter into an oral agreement. No, oral agreement will not suffice. You have written agreement. Section 7 says so. File a suit praying that Y be directed. ऐसा कोई सूट नहीं होता. सूट से आप कभी भी arbitration में नहीं जा सकते. Because there again, if you go under section 89, it will be seen that if you have to go to arbitration, you have to file a written agreement. So agreement करो. File an application under section 11 of the Arbitration and Conciliation Act seeking reference to dispute to arbitration. 11 में क्यों जाएंगे जी? देखें, 11 is appointment of arbitrators. Arbitrator तब अपॉइंट करोगे ना जब arbitration के लिए बैठोगे. कोई मतलब ही नहीं 11 का, तो यही है. 1 is your answer. What is the date of commencement of arbitration proceeding in relation to a particular dispute? It is the request wala. Date of first hearing before the arbitral tribunal? No. Date on which a request for the dispute to be referred to arbitration is received by the opposite party. ये तो straightforward question है. Very much straightforward. I tell you the exact address. Yes, section 21. This is date on which, so straightforward question. This is based on bare provision, nothing. In an arbitral proceeding with 3 arbitrators, the arbitral award must be signed by all the 3 not required, majority required hoti hai. Any 2 arbitrators, which must include the presiding arbitrator? No, majority is written. Any 1 arbitrator so long as the reason for any 2 arbitrators so long as the reason for any 1 omitted signature is stated. Yes, out of 3 majority, it is written. Remember the section if I can get hold of the section. It is where they frame the arbitration forms and contents of arbitral award, section 31. You see the index. 31 में कहीं पे है, majority में होता है हमेशा. 3 out of 3, 2 must sign, and 1, if 1 is not signing, that means majority must sign. If there are 5, then 3 must sign, and if 2 are not signing, then in that case they must give reason why you're not signing. So this 4 is your answer. 4 is the correct answer. Then an application under section 33 of the Arbitration and Conciliation Act cannot seek correction of any computation error in the award, correction of clerical or typographical error in the award, review of the award on the ground of an error apparent on the face of the record, interpretation of a specific point or part of the award. यही लग रहा है नहीं, ये computation और errors तो वो हटाते, it is also written somewhere, but I am confused between these two. Review of award on the ground of an error apparent on the face of record. There is a specific section to it, clerical errors. सेक्शन 33 टेक्स्ट में देखिए, सेक्शन 33 उसी में लिखा हुआ है, करेक्शन एंड इंटरप्रिटेशन ऑफ अवार्ड. लेट्स सी सेक्शन 33. may request the arbitrator to correct computation errors, clerical typographical, ठीक है, correction of computation errors, ठीक है, computation error, clerical typographical or any other error of similar nature, review of award on the ground of an error apparent on the face of record. If so agreed by parties, a party with notice to the other party may request to give an interpretation of a specific point. Okay, this is not wrong, this is correct, this is wrong, ये नहीं हो सकता. See, I was confused. To be true. Sometimes you only remember a part of it, that okay, correction and clerical errors can be done. वो एक पढ़ा हुआ रहता है तो दिमाग में रहता ही है आपके. But then you have to read each and everything properly. Third is error. An appeal under Section 37 of Arbitration Conciliation Act 1996 would not be maintainable against an order refusing to refer the parties to arbitration under Section 8, dismissal of a petition under Section 34, refusing any measure under Section 9, an order allowing an application under Section 8. Would not be maintainable against an order allowing an application, an order refusing. Okay, 43, this would be Section 37. Let's see it quickly. Appealable orders, refusing to refer the parties, okay, refusal, okay, setting aside, refusing, granting or refusing to grant any measure, ठीक है, dismissal, ये आंसर है आपका 4. All right. See, if I would be going like this. These are the questions that I will face problem with, even though they are straightforward questions. इसमें कोई concept नहीं लग रहा, ये bare reading से काम हो जाता है. Only the bare reading of the provision will give you the answer. These all are straightforward. It is legally impermissible for an arbitrator to comprise of 3, 5, 7, 4. 4. 2 is their answer. You cannot have even. You always will have odd numbers. 3, 5, 7. ये तो लिखा ही हुआ है ना उसमें. Section 10 में लिखा है. A settlement agreement arrived at during the conciliation proceeding under Part 3 of Arbitration Conciliation and the same footing as an order made under Section 9, Section 17, preliminary decree of a civil court, arbitral award rendered under Section 30. I hope it is this. Arbitral award. I'm pretty sure it is this. Settlement agreement. It is given in Section 30. 30 settlement, and it is the third, 33. Section 33. It is like this only, as an arbitral award, that it is an arbitral award. As an arbitral award rendered under Section 30. Yeah. 4 is an answer. I'm sorry for delaying a little bit. A person X is appointed as the conciliator to attempt conciliation of the dispute between party A and party B. The conciliation proceedings are terminated pursuant to which the parties seek adjudication of their disputes through arbitration. Which one of the following is a possible scenario? X is appointed as the nominee arbitrator of party A in the arbitration proceeding. X is appointed as the sole arbitrator through a judicial order passed under Section 11. X appears as a witness in the arbitration between party A and party B, despite X is appointed as the sole arbitrator with the consent of party A and party B. Okay. Actually, for this question, I have asked to take out the answer. Even I was clueless. Let me see where it was written. Okay. 69. it would be fourth option, and this was based upon the reading of section 80. Section 80 of Arbitration Conciliation Act. If you read this, you can get to this point. So 4 is your answer in this. Just read it and see, because I am not delving more into it. A party filed an application for interim measures of protection before a court, which was disposed of. The other party also wishes to file an application for interim measures of protection. It is allowed. He may do so before the same court where the party had first filed an application for interim measures. Yes, before the court within whose jurisdiction the seat of arbitration is situated. Only before High Court. Any यही first ठीक लग रहा है मुझे तो. Yes, this can happen. ये first ही आपका answer. I don't remember the section, but you can always see that. I'm making it a little quick now. An arbitral tribunal shall have a lien on the. It shall have lien on the arbitration cost. Have a lien on arbitral for administrative fee. For only legal fee, not only legal fee, not the statement. Not have an unpaid cost of the arbitration. Yes. Not have a lien. No. It have a lien on this unpaid cost. Yeah, this is the answer. 4. 4 is your answer. 71. Lien. You can check the section. It is written directly in the section. In arbitration, they have asked you everything based on the provisions. They have not asked you any analytical question, which is good. And they have asked you around how many questions? They have asked you around 14 questions from arbitration. And I think most of them are coming directly. So it is a good avenue. Factual question. Under section 11 of arbitration, the arbitrator has to be appointed within 30 days of arbitration agreement, arising of the dispute. Failure to resolve, it is the within 30 days from receipt of request for appointment of arbitrator from the other party. This is section 11. They have given you the section. You can read. This is the answer. This is correct. The factors that could disqualify the arbitrator inter alia are: the arbitrator is a partner in a law firm acting as a counsel for one of the parties. The arbitrator has a commercial relationship with an affiliate of one of the parties, both 1 and 2, only 1, only 2, neither 1 or 2. This particular feature belongs to the appointment of arbitrator, and in appointment of arbitrator, section 12. If you read section 12 and that to section 12.5, it will take you to 7th schedule. Section 12.5 and 7th schedule will tell you that these both are correct. Answer is 1. Very straightforward, but they take you to places. They are taking you to every place whatsoever. They are very exhaustively, they have asked questions. But none of the question is something that you cannot attempt if you have read the entire BERAT properly. Which of the following is an incorrect statement? An arbitral award is a contract. No. It is not a contract. Contract में तो offer acceptance होती है. An arbitral award must be in writing and signed. Yes. It is, but not incorrect. An arbitral award includes an interim award. Yes, this is the definition of arbitration. This is incorrect. 1. A nomination of an arbitrator is made by a person who is himself ineligible to act as an arbitrator under section 12.5. अभी 12.5 का हवाला लिया था. Read with 7th schedule. See, 12.5 read with 7th schedule. 2 question पूछ लिया आपसे इसी में. To the arbitration, in such case, the nominee cannot act as an arbitrator. Such nomination would be void ab initio. Such nomination is valid. Okay. The answer would be 12.5. 12.5 में दोनों ही लिखे हुए हैं. Both 1 and 2 is your answer. 3. If you know, you know. That means this is something which is barely based upon the provision. कोई दिमाग नहीं, कोई एनालिसिस नहीं लगाना. अगर आपको ये सेक्शंस पढ़े हुए थे तो सब आता है. For purpose of limitation act, hundi is not a bill of exchange. Check is not a bill of exchange. Hundi is a bill of exchange and check is also a bill of exchange. This is wrong. 48. This is incorrect. 3. 3 is your answer. Clear. This is incorrect. Hundi is a bill of exchange. Check is a bill of exchange. Why would they deny? A suit for recovery of money based on pro notice filed, and 1 day after expiry of period of limitation, there is neither any prayer by the plaintiff for condonation or delay, nor any objection taken in written statement by the defendant. Which of the following statement is correct? Suit is liable to be dismissed. Yes, it is liable to be dismissed. The suit cannot be dismissed on the ground of bar or limitation because there is no issue raised. ऐसा नहीं होता. It is liable to be dismissed. Because even if it is not raised, section 3 says specifically that it is the duty of the court. The delay of 1 day is significant. No, not the above. 1 is your answer. 1 should be your answer. Then next, I think this is the last leg of the video. It is a very long video now. Mark the correct statement with reference to period of limitation. Where the plaintiff claims to be a pauper, the suit is deemed to be instituted when his application for leave to sue as a pauper is allowed. Not allowed but made. अगर कहीं लिखा हो तो हाँ ये made ही लिखा हो. This is given under section 3 only. 2 is your answer. ये तो बहुत straight forward question. में तो कोई problem नहीं. Following usual practice, New Delhi courts located at Patiala House Court complex were closed post lunch on 25th January. अच्छा closed post lunch. कोर्ट क्लोज हो गया है. साफ दिख रहा है, सेक्शन 4 लग रहा है. सेक्शन 4 में लिखा हुआ है अगर यूजुअल वर्किंग आवर्स में वो काम नहीं कर रहा है तो हम क्लोज मानेंगे. यूजुअल वर्किंग आवर्स में उसको क्लोज कर दिया गया तो क्लोज ही मानेंगे. Then on 27 January filed a suit against B, but period of limitation ended on 25th. ठीक है, 26 की छुट्टी थी, 25 को भी वो बंद माना जाएगा, 27 को आया, ठीक है, एक दिन एक्स्ट्रा मिल जाता है. सेक्शन 4 में लिखा है सूट इज नॉट बार्ड. ठीक है, सूट इज बार्ड ये नहीं ठीक, सूट इज बार्ड ये नहीं ठीक. ऑल द अबव करेक्ट नहीं है. 1 आंसर है आपका. इसमें तो ज़्यादा फिल्टरिंग है, स्ट्रेट फॉरवर्ड है. A filed a suit for recovery of 10 lakh. It was B's case that A owed him rupees 20 lakhs, but B had not filed a suit to claim the said amount as the limitation period has expired. Which of the following is true? B cannot raise his claim as it is barred by limitation. है तो ये सही. B can raise his claim by way of separate counter claim. ये भी वो कर सकता है. B can claim set off in the written statement. Yes. B gets a new cause of action for filing a fresh suit after filing a suit. No. देखो, अच्छा B cannot raise his claim as it is barred by limitation. ये तो सही बात कर रहे हैं ये. B can raise his claim by way of separate counter claim. Counter claim में ला तो सकता है, पर सेट ऑफ भी दिया हुआ है तो सेट ऑफ बेटर है क्योंकि मनी टू मनी क्लेम होता है. तो ये हम अभी फिल्टर आउट कर देते हैं. B can claim set off in the written statement. He can claim set off in the written statement. Yes. And why he can claim set off? He cannot raise his claim as it is barred by limitation, which is true. It was B's case that A owed him rupees 20, but B had not filed a suit to claim the said amount as the limitation period has expired. अब इसमें ये भी नहीं लिखा क्वेश्चन में कि that if can he file a set off. If the question says that he can he file a set off, then he can file a set off. फिर ये ठीक हो जाएगा आपका. But if it is asking which of the following is true, then B cannot raise his claim as it is barred by limitation is good. ये तो सही बोल रहा है. And B can claim set off in the written statement. This is also correct. Because if you see section 3 Limitation Act, sorry, section 3 Limitation Act says that section 32B1 32B1 अगर आप इसको देखें लिमिटेशन एक्ट, it is saying that any claim by way of set off shall be treated as a separate suit and shall be deemed to have been instituted in the case of set off on the same date as the suit in which the set off is pleaded. That means whenever A filed the suit, if on that day it was not barred by limitation and B claims 20 lakh rupees by bringing a set off, then it will be considered that it is filed on that day when A filed the suit. Saying that it is true, but if we go by the question, I cannot find out the intent of the question saying that if B can a set off be can in a set off B be allowed to recover 20 lakh rupees. ऐसा कुछ नहीं पूछ रहा. एक बहुत सिंपल स्टेटमेंट है, A filed a suit for recovery of 10 lakh against B. It was B's case that A owed him 20 lakh, but B had not filed a suit to claim the said amount as the limitation period has expired. भाई उसने limitation period expire हो गया तो उसने सूट नहीं किया. Which of the following is true? इसमें से क्या true है? B cannot raise this claim as it is barred by limitation. This is true. No doubt about it. B can raise his claim by way of separate counter claim. Counter claim नहीं कर पाएगा क्योंकि ये 3(2)(b)(2) ये कह रहा है कि काउंटर क्लेम उसी दिन होता है. अब ये तो उसी दिन होता है जिस दिन इंस्टीट्यूट मतलब काउंटर क्लेम प्लीड करेगा. काउंटर क्लेम इफ ही इज प्लीडिंग देन इट विल नॉट बी अलाउड, बट सेट ऑफ कैन बी अलाउड if only if on the date of filing of the suit by A, only if at the date of filing the suit by A, the claim of B was not barred, only then the set off will be allowed. अब ये तो मुझे इन दोनों में confusion लग रही because they both are true. So I have my reservations to this question. It can be either one or either three, any of the two. Objections may be raised. Where one of several persons jointly entitled to institute a suit or make an application for the execution of decrees under a legal disability and a discharge can be given without the concurrence of such person, time will run against them all. Yes. Discharge can be given without the concurrence. This is true. Section 6, 7, 8, 9 says so. Section 7 particularly. Where no such discharge can be given, time will run as against such of as do not suffer from any such disability. ऐसा नहीं है. Time will not run against them all. That means this is wrong and this is true. A is right, B is correct. कहीं लिखा है? Statement A is correct and statement B is incorrect. यही ठीक है. One is your answer. Section 7 पढ़ लीजिए, दोनों आपको दिख जाएंगे. Mark. In computing the period of limitation for any suit, appeal or application, the day from which such period is to be reckoned shall be excluded. 12(1) बिल्कुल ठीक है. In computing the period of limitation for an application for review of a judgment, the day on which the judgment complained of was passed, if pronounced in open court in the presence of the party, cannot be excluded. ये गलत है. This is wrong. ये तो both 1 and 2 are correct. नहीं, both 1 and 2 are incorrect. नहीं, ये 1 ही correct है बस. 105. 1 is correct. 105. Clear? चलें आगे. In computing the period of limitation for any suit, the time during which the plaintiff had been prosecuting another civil proceeding against the defendant in a court which from defect of jurisdiction or other cause of like nature was unable to entertain it shall be excluded, but it is necessary that the other case was prosecuted with due diligence and good faith. ये तो requirement है. It is not necessary that the other state related to same matter in issue. ये गलत है. It should be same matter in issue. Same matter in issue होना चाहिए. Necessary. The defect only related to territorial. नहीं ऐसा necessary नहीं है. All are correct. नहीं सही है. सिर्फ 106(1) correct है. सिर्फ पहला ही correct है. Section 14 से आप पढ़ लीजिए, यही मिलेगा सब आपको. तो सबको याद है ही. लिमिटेशन एक्ट में तो एक सेक्शन आपने रटा होता है. Where the suit is based upon fraud of the defendant, the period of limitation shall not begin to run until the plaintiff discovered the fraud. बिल्कुल ठीक है. Be deemed to be 12 years from the date. नहीं, ऐसा कुछ नहीं. This is 1 is your answer. Because it's both are correct, both are incorrect does not make any sense. Which of the following is not an essential requisite of a valid acknowledgement? Under Section 18 of the Limitation Act, it must be made before the expiration of limitation period. Yes. It must be signed by a person making the acknowledgement or by his duly. Yes. It must be made by the party against whom any property right is claimed or by some other person through whom he derives title. Yes. It must bear a date in writing. If you see Section 18 particularly, you will see that this writing is not given. Shall be acknowledgement was so signed. Where the writing containing the acknowledgement is undated, oral date is the requirement. Date, but a date in writing is not the requirement. It can be proved otherwise. 4 is the answer. Because these 3 are the requirements. So anyhow, if you can filter, this is the 4. 4 is your answer. So in this video, I have reservations. That means I have some contentions with respect to question number 61, 63 and 91 of set B. You can check that. If you have the correct answers, it's okay. Otherwise, I have a doubt. That was all for this video. It was a long video, but kindly do read it, do see it, and see that how we have tried to find out the answers. Thank you so much, and we'll see you in the next part. The third part, it will be small because only few of the subjects are remaining. Thank you so much.